the co-author of a casebook on intellectual property and copyright in particular. She has been elected to the AOI for the restatement of copyright. And she is the author of one of my favorite articles, Fair Use and Affirmative Defense, which some of you may know as being cited in the Lens case, where we finally got confirmation of fair use as a excuse to infringement and not as an affirmative defense. So she's very famous for that. We will then hear from Francis Malofiy, who's joining us also on the screen here. Thank you, Francis, for being here.
Sure. I'm sorry I'm not there in person.
Yes, we're sorry not to have you here. Francis is perhaps best known at the moment for being the lawyer who is suing Led Zeppelin on behalf of Randy Wolfe, California's estate. Led Zeppelin is nonetheless a group that he calls still his favorite band. So he can talk to us a little bit about that. He was also behind a $44 million verdict against Usher and the writers of Bad Girl in 2018. So he will give us some thoughts on where substantial similarity cases are and what he's noticed as being an important focus of them. Kenneth Freundlich will then speak with us. Kenneth has been working in music and for artists for over 30 years in various capacities as a lawyer, as a producer, as the owner of a digital record label. He's also counsel of record for some of the most important and influential amicus briefs that have been filed in this area, including recently an amicus brief filed on behalf of musicologists in the dark horse case that we were discussing earlier in this conference. Then we will close out with Richard Busch, who many of you know, and my copyright students need no introduction. He is the representative for the Gaye estate in the Blurred Lines litigation. Before that, he has done lots of work for Bridgeport, such as in Bridgeport versus Dimension Films, Bridgeport versus UMG, most recently in that arena, the VMG Sal Sol versus Chacon case. And we are especially grateful to have him here as he has been very busy lately securing an unprecedented temporary restraining order on behalf of Megan Thee Stallion. I don't know if anyone's been following this case, but this TRO allows her music to be released tomorrow, where her record label was otherwise not going to allow that to take place. So I believe he argued an emergency just now, and now he's here to join us. So without further ado, I'll turn it over to Lydia. She's going to discuss some procedural points, including burdens of proof, and then we'll move on to Francis, Kenneth, and Richard, and then have some rebuttals and discussion amongst ourselves. Take it away, Lydia.
All right. Well, thank you very much. I really want to thank Kristelia for organizing such a great gathering, and I want to thank all of the participants for their thoughtful and thought-provoking remarks. And also, I really want a big shout out to the IT staff at UC Boulder for making it possible for me to participate remotely. Is the sound coming through okay? Everything good?
Yes.
Perfect.
Yeah. Fabulous. Okay. Well, so I've been following the Twitter feed for the conference, and I want to flag something that Professor Blake Reed said. He said, watching people argue about different theories of substantial similarity is like watching athletes playing different sports against each other on the same field. So this is the legal panel. And so what I wanted to do was focus my remarks on the very important part of the structure of civil lawsuits. And that is the burden of proof within the structure of the copyright infringement lawsuit. And by doing that, I hope to get us all at least playing the same sport. So there are some PowerPoint slides. They're available on the conference website, but I can't both be there remotely and show you the slides. So so you can pull the slides if you want to follow along with the slides. But we all know that in a civil lawsuit, it's the plaintiff's burden to prove a claim of infringement. And what exactly the plaintiff must demonstrate to successfully carry that burden is actually not expressly laid out in the Copyright Act. So instead, we look to the Supreme Court for the modern articulation of the prima facie case of infringement. According to the court in Feist, a plaintiff must demonstrate two elements, which the court helpfully numbers for us. One, ownership of a valid copyright, and two, copying of constituent elements of the work that are original. But unfortunately, that numbering is misleading, right? Each of those two elements actually has two parts to it. So the first element is both ownership and validity. And then the second element is both copying, right? That the defendant copied from the valid copyrighted work owned by the plaintiff, and also that the copying was improper, that it was copying of elements of that copyrighted work that are original, and enough of them that we would call it substantially similar. So we go from 2 elements to 4 elements, and it's improving that final element, the final number 4, and the final 2 elements, number 3 and number 4, where the similarities in the 2 works, which is the focus of the conference, are relevant. So in 2018, the Ninth Circuit issued a decision in a case involving 2 photos of Michael Jordan, the Rentmeister decision. So it's Rentmeister versus Nike. And the Ninth Circuit helpfully labels those 2 final elements as copying and unlawful appropriation. And I'm going to try to use those labels for clarity. So before examining the role of substantial similarity in more detail, let me return to the concept of burden of proof. So we say that an infringement plaintiff bears the burden of proof on a prima facie case of infringement. And what that really means is that the plaintiff bears the burden of persuasion. Convince the jury that the elements have been shown by a preponderance of the evidence. But then there's also a subsidiary burden that we sometimes refer to as the burden of production, right? And that burden might shift between the plaintiff and the defendant, but always the ultimate burden of proof, the burden of persuading the jury on that prima facie case, remains on the plaintiff. So if the plaintiff has presented sufficient evidence from which a jury could reasonably conclude that the element is met, then the defendant is going to want to raise defenses. Now, some of those defenses are meant to actually chip away at the prima facie case. They're meant to, cast doubt on the story that the plaintiff is telling, make it so that the jury will decide that they are not convinced that the plaintiff has carried its burden. And these types of defenses, I think, it's really important to understand, those are not affirmative defenses. They are instead more accurately characterized as rebuttals. They're rebuttals to the plaintiff's prima facie case. And those rebuttals, they can be factual or they can be legal rebuttals. So the defendant might be introducing some new factual evidence that helps rebut access, for example, or they might be saying legal arguments as to why a particular aspect of the work is uncopyrightable. So this structure of the prima facie case and the role of defense rebuttals, I think, is critically important for a court to correctly apply the tests of substantial similarity. And that's because, right, substantial similarity is used by the plaintiff to prove both the 3rd and the 4th elements of the prima facie case of infringement. And those 2 separate elements, the plaintiff has to prove both of them, right? The plaintiff has to prove the defendant copied from the plaintiff's copyrighted work, the copying prong, and also the plaintiff has to prove that the copying was of enough of the original elements that the copying is improper, what the Ninth Circuit terms the unlawful appropriation element. So take the first of those, that the defendant copied from the plaintiff's copyrighted work. So sometimes we'll have direct evidence. We might have session tapes where we have the defendant saying, hey, let's use that bass riff from that other song, right? That kind of direct evidence is pretty rare usually. And so instead, the plaintiff is allowed to rely on circumstantial evidence. And it's this circumstantial evidence of access plus substantial similarity that allows a court and the jury to infer and conclude that it must have been the case that the defendant copied, right? Why else would the works have been so similar? The defendant had access to the plaintiff's work and they're so similar, there must be the case that they're copied, right? Well, there can be other explanations. And, for example, that's the way songs in this genre sound, or particularly in this genre at this time, or maybe even in this geographic area. That's the kind of music that was coming out of that area or that slice in time. And courts often say that the reason we entertain those types of rebuttal arguments is that, quote, independent creation is a complete defense. But I submit to you that the nature of that defense, it's simply a defense argument in rebuttal to the prima facie case. The burden of persuasion, that hasn't shifted, right? It's still squarely on the plaintiff to demonstrate that the defendant copied from the plaintiff's copyrighted work. Now, even more important, however, is the final element of the plaintiff's prima facie case of infringement, right? That the copying amounted to an unlawful appropriation. Important, right? This element is separate from the copying element, but unfortunately, we see litigants in courts collapsing the final 2 elements into one. So, for example, in the recent Lizzo case concerning the song Truth Hurts, the songwriters cite a musicology report that concluded Truth Hurts duplicated, quote, distinctive elements from the demo that were unlikely to be coincidental. But based on the allegations made by the plaintiffs against Lizzo, we're beyond the stage of focusing on access and similarity. We're beyond the stage of asking about copying in that sense, right? Lizzo was present in the recording session that the plaintiffs point to as the source of their copyrighted work. And instead, we should be focusing on the fourth element, that the plaintiffs need to prove that the copying of just one line of lyrics is enough to constitute unlawful appropriation, right? That final fourth element. Or we see incomplete statements like the court in Gray versus Perry, where they describe the final element as a need to demonstrate, quote, that the defendant copied protected elements of their work, right? Gray needs to demonstrate not just that a protected element was copied, but that enough protected elements were copied, amounting to an unlawful appropriation. So as the Ninth Circuit helpfully reminded us in the Rentmeister case, right, proof of unlawful appropriation, that is illicit copying, is necessary because copyright law does not forbid all copying. Right? Not only does copyright law not forbid copying of ideas and concepts, right? That's not infringement. But the court said, quote, to infringe, the plaintiff must also copy enough of the plaintiff's expression of those ideas or concepts to render the two works substantially similar. And it's plaintiff's burden to demonstrate this final element. So as to the final element, defense rebuttals take two forms, and they are largely legal rebuttals, right? On this last point, on the fourth element. The elements that are similar are not copyrightable, right? That's a legal argument about the copyrightability of different aspects of the work. And then the second sort of legal rebuttal is to the extent that some of plaintiff's protected expression may be present in the defendant's work, there's an insufficient amount of plaintiff's original protected expression in the alleged infringing work to amount to an improper or unlawful appropriation. So, and in this context, right, it's really important. We don't care if the defendant copied from the plaintiff's work. That analysis is left to element 3 for the copying prong. It should not play a role in element 4, the unlawful appropriation prong. And when courts correctly keep these inquiries separate and apply the burdens of proof correctly, we get decisions like the Rentmeister decision. And in the Rentmeister decision, the Ninth Circuit affirmed the dismissal of the plaintiff's claim for failure to state a plausible claim of infringement, right? We're talking about a 12b6 dismissal. So I'm going to show you, I think if I can do this properly, I'm going to put up on the screen there the two images that were at issue in the Rentmeister case. So is that showing up well on the screen? Oh, good. Okay. So, right, this is a 12b6 dismissal. The court looked at these two photographs, right? It assumed all of the plaintiff's factual allegations were true, which meant element 3, the defendant copied from the plaintiff's copyrighted work, that was assumed proven, right? We're going to accept the allegations as true. But in the 12b6 context, the court was able to focus exclusively on that fourth element, on the unlawful appropriation inquiry, right? And again, the court said to prove this component of the claim, Rentmeister has to show that Nike copied enough of the photo's protected expression to render their works substantially similar. And proceeding under the Ninth Circuit's further rather unique bifurcation of the substantial similarity inquiry under what the Ninth Circuit calls the extrinsic test, the court noted that the photos can be broken down, right? They can be broken down into objective elements that reflect various creative choices the photographer made in composing the image. So choices about subject matter, pose, lighting, camera angle, depth of field, and the like. But none of those elements, the court said, is subject to copyright protection when viewed in isolation. So what's protected, the court said, is the photographer's selection and arrangement of the choices of these otherwise unprotected elements. Okay, so we think about choices that are made. I'm going to come back to you now as me, right? I think a similar analysis can and should be applied in music cases. Musical artists, both songwriters and performers, make a variety of choices related to their art form. They choose the words. The words themselves are not individually protectable. They choose the chords. The chords are not individually protectable. Time signature, pace, you name it, right? But none of those elements in isolation is subject to copyright protection. The combination of those elements, it's the choices made in the selecting and arranging of them that achieves protection, right? And this is consistent with what Reagan Smith was explaining in the last panel. And it's only when allocating a sufficient amount of those choices, not merely one or two, or maybe even a few components, that the similarities should be viewed as sufficient to permit a reasonable jury to conclude the plaintiff has satisfied its burden of demonstrating that fourth element of the infringement case, unlawful appropriation. Now, in Rentmeister, the Ninth Circuit acknowledged the two works share undeniable similarities at the conceptual level. But then the court went on to articulate the numerous ways in which the works were different, where different choices were made by the Nike photographer. And importantly, it was these differences in the choices made, as reflected in what the court called the photo's objective details, that precluded, as a matter of law, right, 12b-6, a finding of infringement. So in other words, there was no way that a jury should even be allowed to hear the case, right? There was no way that a jury could permissibly conclude that Nike engaged in unlawful appropriation, even if Nike did copy from plaintiff's photograph. There was no way, right, on the facts alleged that the plaintiff could plausibly carry its burden, the Twombly-Iqbal standard that we use for 12b-6 motions, right, plausibility. And similarly, I think in music cases, focusing on the fourth factor, the fourth element, right, of the unlawful appropriation, isolated from the third element, the element of copying, and encouraging consideration of both the nature of the similarities between the works and the quantity of differences in the defendant's work can help us really focus the analysis and allow us to use a phrase that Kevin Erickson used on the previous panel, right? Engage with the complexity of the fundamental question, right? Which is determining what should and should not count as an unlawful appropriation. So I'll end there and I look forward to questions.
Thank you very much, Lydia. Francis, we will turn over to you now. Again for joining us.
I appreciate it. First, this is the first time I'm ever doing this, so it's a little unusual for me. I guess everyone can see me. Am I big on the screen, or how does it work?
You are on the screen. We can see you.
Oh, great. Okay, great, kids. Look at you. That's it's funny. Anyway, I wanted to be in there in person. I wasn't able to. I'm involved in a very big case I've been working on for about 3 years and full time, 7 days a week for the last, since October. It's imploding a global corporation in real time. I can't tell you who it is or which corporation, but you'll see about in about 2 to 4 weeks, you'll read about it. So I apologize not being there. You know, I think it's the whole copyright litigation, it's so skewed, and that no one really understands the reality is of how hard it is to bring a case to trial. Everyone's acting and talking all this scholarly way, but who has actually taken a case, a music copyright case, to trial? Very, very, very few people. So you hear a lot about comparing this and comparing that and substantial similarity. And this is all textbook stuff. It's great. But until you've actually taken the case to trial, it's a very, very different world. And it's a bitter world, right? And it's sort of like I stand on that line like the Lord Commander, right? Between good versus evil. And it's that simple, right? You have the creatives and you have the industry. And the creatives are there to protect that which they created. And then you have the industry that all they care about is one thing, their dollars and cents and their bottom line. It's such a disproportionate playing field. It's so disgusting, right? That we're even sitting here having conversations about, oh my God, the floodgates of copyright cases. What's going to happen? And we're all buying into this. We're all buying into this sort of, this concept. We're talking about this idea, the floodgates, the floodgates. How many significant copyright cases ever get the verdict in the last 20 years? You can count them on your hands, right? We're not talking about a floodgate. People throw around terms like $1 million or $2 million. It is meaningless. How do you know that? Just look at the comparison, the disparity in income, the disparity in net worth between a songwriter who has nothing at all, and a global corporation, right, who brings in not millions, billions of dollars. All right, let's put this in perspective. The average songwriter makes how much a year? Nothing, okay? That's what he makes, the average songwriter. How about, that's the truth. How about the average American? 30,000 to 50,000, let's say. And you got tons that make zero and you got some that make a lot. So depending on how you factor in your average or your mean, it's going to shift. So 33 to 50,000. We'll use 50,000. Okay, $50,000. That's not what a songwriter makes. They make zero. Let's talk about what Sony Music Entertainment makes a year. What do they make? $8 billion. Okay, $8 billion. And they're talking about, they're concerned about $1 million. It's like a grain of sand in all the beaches in the world. It's nothing to them, right? So when we're talking about these things as if they actually matter, put it in perspective of the haves and the have-nots. You have a songwriter that all he's trying to do is get recognition for something that which he created. And then you have an industry that has the best lawyers, the biggest firms that will do everything to push him down, stab him in his back, and do everything to not give him a penny. And then what do? How does that songwriter even get to court? He has to find a lawyer who's crazy enough to take a copyright case to court. And how many of those are there? Very few. And how many of them that are successful? Even fewer. And how many of them actually tell their client, you know what? I believe in your case. So what I'm going to do is I know you have no money. You don't have really a roof over your head. Where you're at mom's house, your dad's house, sleeping with friends, struggling. So do you have the 150,000 just to get it to trial? No, of course he doesn't. So what lawyer or law firm is going to take this on a contingency and put in 150,000 and potentially, most likely, get zero in the end, and even 3 times that the amount of time and effort that went in? All right, hold on a second here. I don't know what my screen's doing. Oh, can you see that? Jesus, I hope not.
No, we can only see you.
Oh, good. Look, I've never done this. It has some email thing coming through. It's apparently telling me to buy a Desert Eagle. Great. It sensed my anger. Okay. There, I'm back. Okay, sorry guys. Let me get back to it. All right. You have these academics and you have these people like Algo Boy, the Geek Boy, the guy who did the algorithm. You know who I'm talking about, right? Who's trying to break down, yeah, I see in the back there. You got the beard, longer hair, right? You understand what musicians go through, all right? You got Geek Boy, who's trying to destroy the most sacred part of music, which is your melody and harmony, and break it down to not even 12 notes. Forget all the other octaves. Break down the 8 notes. And then let's just completely bastardize music as we know it and get rid of all duration of notes. All right? A T is always a T is always a T in the English language. How many letters are there in the English language? 26, right? How many notes are there? 12, right? Hey, no one's running out of books to read. No one's running out of books to write. What's incredible is that in music, you have far more combinations than you do in the English language with 26 letters. Because you can have an A or B or a C or whatever the note is. You can hold that for a quarter note, an eighth note, a 16th. How it modulates back and forth, the timing of the actual music changes it. He's breaking up 8 notes, making them all basically quarter notes, as if there's no duration in a note. So basically, he's limiting the scope of this of what they're actually analyzing to almost the smallest, minute comparison. It's meaningless. It's garbage in, it's garbage out. Geek Boy, Algorithm Boy, losers. Okay, they're not there to protect songwriters. They're not. And you know what? He can't tell that guy. He's never tried to case the verdict. All right. Look, let me make it really clear. I did this on my own. I did it by myself. All right. I represent the creatives against the industry. I've been doing this 11 years. I'm undefeated in jury trials. The 2 cases I lost, I overturned the appeals and set law. All right. That's an amazing, amazing track record. You got these people that want to talk about, the difficulties in prosecuting the case and the burdens of proof. A plaintiff has an incredible burden of proof to show that he actually wrote something that they actually was stolen from him. Right? The federal courts are going to be slanted to where? To the industry. They always are. It's just the way it is. It's a fact of life. Federal courts, whatever industry is in that community, whether it's the film industry, the banking industry, the insurance industry, federal court's going to side with them. oh, you're going to hear a lot about how the federal courts are the most fair courts and they're appointed for life and all this stuff. Not so. All right. The difficulties is, yeah, it's great if you're a defendant. It's great if you represent the defendant. But if you're actually representing the plaintiff, the creative, forget it. It's not a fair fight. We know that. Now, you have all these scholarly literary types talking about this nonsense about, oh, thin copyright. This drives me nuts, right? Let's be clear. The purest form of art is music. Not because I said so, because it is. Because Martin Scorsese said so. He didn't say film was. The purest form of art is music. Why? It evokes more emotion than any other form of art. How do we know that? Let me give you point in check. I went to Paris. You go, you look at the Louvre, right? You walk through. Have you ever seen? Raise the hands. Who saw the Mona Lisa? Okay. Did you cry? Were you like struck by its beauty? Did you drop to your knees? Did it throw you back to when you were 16 and your first date? Well, maybe not your first date. Maybe something more than that. 16. I don't know. Kids these days. You know, you're 16. Maybe you're driving your car. You're driving it fast. Look, the whole point is that you go by the Mona Lisa. You wait in this line. You walk by. And you're like, okay, big deal. Is that what that's about? It doesn't evoke the same emotion. Why is music the purest form of art, and why does it actually matter, and why should it not be given thin copyright? Because the beauty of music is that it's associative, right? If you read a book, all you do is read the book. You're sitting in bed reading the book. If you watch a movie, what do? You're sitting on a couch watching a movie, okay? It's not associative in that it doesn't intertwine with your DNA and your experience of life. But what does? Music does. What also does? Because you're all in Colorado, right? Drugs do too. You smoke weed. Colorado's big on that. Okay? Drugs are associative, right? They throw you back to times and places. This is what I read in the literature, the scholarly literature, right? You know, you remember the first time you got drunk. You remember your senior prom. Maybe you had some hits of ecstasy. I don't know. Okay? I don't know what the kids are doing these days. MDMA, Molly, whatever. Okay? The point being is that music is associative. That's why it's so compelling. It throws you back to a time and place. You hear a song, you go there, you feel it. You might shed a tear, right? You do music while you do other things. You be driving fast in your Mustang, posi rear. Maybe you got a slap shifter on it, 302, 5-speed, whatever it is. Doing burnouts. You're playing some Guns N' Roses. I don't know. Okay. But the point is, you're at a senior prom. What do you listen to? Bob Seger or something? I don't know. The point is that they're associative. Why should music be basically chopped down to facts and thought about not in a way that's creative or that how it evokes emotion, but let's break it down to math and math magic and, Algo Boy. Okay. Point in check. No one will ever steal that Algo Boy's music. If you've ever heard it, it is the worst thing objectively.
Okay.
It's the worst music you could ever hear on the face of the earth. This man has nothing to worry about. I mean, it is like it's bleeding ears. It's embarrassingly bad. For him to say he even is a songwriter, a producer, or work with musicians, it's embarrassing. Okay, it is so bad. It's actually offensive. And you hear it and you're like, oh my God, dude, no one's going to steal that. Okay. He has nothing to worry about.
Thank you, Francis.
Now,
we're going to, if I can, we'll come back and give everyone a chance to respond. I want to make sure we get time to let Kenneth respond or present his stuff, and then Richard, and then we'll circle back to the group.
Let me just finish up this point.
Okay.
Thin copyright. Okay. Music has never, ever been thought of in any way to be a thin copyright. It's full and broad copyright. It's the most complex of the art forms. It evokes more emotion than any other form of art. And for that reason, cannot be curtailed and minimized to be something so narrow as a thin copyright, right? And it never has been, it never will be. And for the industry and for even scholarly intellectuals to even try to really bastardize copyright law, to take protection away from songwriters and protect the industry, it's really disgusting, should never happen. I gave it to you straight, kids. There you go.
Thank you. Thank you.
No bullshit.
Kenneth.
I've been practicing law for 35 years. I've never had to quite follow that type of presentation, but I'm going to give it a shot. How do I come to this? I've had experience on the plaintiff side of this for quite some time. I also was on the defense side of the Thou Shalt Not Steal case. That was the sort of beginning of judicial hostility to copyright infringement. I have recently been hired by a group of musicologists. It's between 13 and 15, depending on which brief. So I've submitted an Amici brief in the Blurred Lines case, the Led Zeppelin case, and the Katy Perry case. So I'm going to try and present on all three that kind of can weave it together, because it seems like these are the three big cases that are causing quite a stir in terms of the current music copyright community. We have a system. We've talked about the system, and we'll all admit as lawyers that it's not a perfect system, but it is the system we have. The copyright is based on statutes. The professor laid out the burdens of proof the way the courts have established it throughout the time, and that's the system that we have to live in. We also have a system with juries, and by putting a case before a jury, you're bringing in all sorts of elements, the credibility of witnesses, the experts, their credibility, and so what we find, what the musicologists find has happened recently is that many of the cases have gone to a jury, and it's become less about the math of the music, the actual music, and more about all kinds of other factors. And so what we tried to do in all three of these briefs is kind of rein it back. So I'm just going to kind of sprinkle my way through the three cases in the time that I have. The first case is the Blurred Lines case, and Richard will tell you about it. Richard won the case, and my hat's off to Richard for having done that. But the way I look at it, the way my clients have looked at it, is that there were two songs that were not similar. The melodies of the songs were different. The basic harmonies of the song weren't the same. So what happened was they hired a musicologist, and this is they refer to it as a constellation of similarities. Judith Fennell, who was the musicologist, presented this constellation of similarities, and it was a whole mess of factors. It was timbre, it was key, it was things that were other than what we believe are the fundamental building blocks of music, which are melody, harmony, and rhythm. And so what happens when a case gets to a jury, it means that it survived the judge's, basically the judge's denied summary judgment. I don't know how many of you know what procedure is, but basically the case starts off and the litigators are going back and forth in front of basically a judge. And there's discovery, and the depositions take place, and there are discovery disputes. All of this is with a judge. And then at the end, for these cases, at the end of the evidence, when the experts have been deposed, when everyone's been deposed, a lot of times the defense and sometimes the plaintiff will make what's known as a motion for summary judgment. And the judge will basically be asked to say, there's nothing here to send to the jury. In other words, it's either the plaintiff's case is so overwhelming that we're just going to give verdict to the plaintiffs, judgment to the plaintiffs, no jury needed. In the case of Blurred Lines, the defense made such a motion. And the appellate decision, which affirmed Mr. Busch's verdict, the main point that the Amici were trying to make was that the judge himself, the judge is supposed to be a gatekeeper on these cases. But the reality is that, as we've heard before, judges don't know music for the most part, or they don't want to stick their necks out and rule on any music. Do they have a clerk that's a musician? Do they have a son at home that's a musician? I mean, where are they going to get their knowledge from? It's really difficult. I was happy to hear Sandy Wilbur say that she had been appointed as a court-appointed expert, and that's like 13 years ago, because one of the things that I've been saying is, and we really believe, musicologists, and I'll say I really believe as well, that Judge Kronstadt was required to make a decision. What he said in his ruling, and I don't have the language right in front of me, but it was something along the lines of, This expert opinion makes sense to me. This expert opinion makes some sense too. I'm not going to decide. I'm just going to send it off to the jury. But the judge is supposed to make, on the extrinsic test, which you've heard a lot about, it's supposed to look at the two experts and decide whether or not one of those experts is right or one of those experts is wrong. And the judge didn't do that. Now, for reasons that sort of go beyond the scope of what we're talking about here, the appeal which the Amici focused so hard on was to say the judge made a mistake. You had to go back to the judge and make the judge look at this stuff. That summary judgment ruling was not appealable because of certain things that happened procedurally. So, you know, most of the Amici role was kind of rooted in the blurred lines case. But suffice it to say that as I've been looking at the history of all this, I really believe that whatever made the judge in the court with Sandy appoint Sandy as the expert, I think there's procedures in the federal rules that provide that one can ask the judge to appoint a special master or a referee, or whatever you want to call it, in some way that the judge should admit, okay, I don't know this music stuff. I'm not going to just send every case to the jury, and I'll tell you why that's not a good idea in a minute, but I need somebody to help me make this decision. So I'm hopeful that in the future somebody at least tries that path. Because once a case goes to the jury, you run into a fundamental problem, which is the jury, the oral representation of what the jury hears has just too much weight. And switching ahead for a minute to the Led Zeppelin case, if you hear those two guitar parts, and you hear it played by guitar, and it just sort of sounds like, oh my God, it sounds the same. But when you break it down musically, all that's similar there is bum, 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 just a descending bass line is basically what it boils down to. And in that case, the jury, I believe, got it right, that wasn't enough because that descending bass line is all over the prior art. Francis was successful in getting the case overturned because the judge didn't instruct about selection and arrangement. And then now that the Led Zeppelin case went up en banc and the Amici put in a brief, and I just want to quote a little bit because one of the things that we cited in the Led Zeppelin brief en banc, which is something that I commend you all to read, is the dissent in blurred lines that Judge Nguyen wrote, and I'm just going to read some of that. She said, the experts' cherry picking might be reasonable if the two constellations bore any resemblance, but Big Dipper and Little Dipper they are not. The only similarity between these compositions is that they're both compositions of stars. What she meant by that is, yes, the expert, who was Ms. Fennell, threw together this panoply of unprotectable elements, timbre, cowbell, melisma, I think she called it. But the melody, harmony, and rhythm was different. One was ba 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 ba. One was bum 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 bum. It's really not the same. And I know that in the courtroom, I'm sure I wasn't there. Ms. Wilbur probably had a keyboard sort of like this, but I'll spare you the sounds, and played it in that way. But in the Blurred Lines case, because it was before a jury, and again, I wasn't there, but I'm sure that Richard did a phenomenal job of portraying the untrustworthiness, if you will, of the witnesses, because as many of you maybe have read, both Robin Thicke and Pharrell Williams were kind of giving the finger to this whole process, and Robin Williams said some things to the press, Robin Thicke said some things to the press that were regrettable, and so as a jury trial matter, it became about a lot more than whether the music was substantially similar in that particular case. In the Zeppelin case, there is an appeal en banc which is pending right now, and yes, the thin copyright is a big issue there, and basically what a thin copyright means is if you don't have copyright of melody, harmony, rhythm, of things that are protectable, and instead you have a panoply of unprotectable elements, there are cases in the Ninth Circuit where those unprotectable elements can, in and of themselves, create an infringement, but the copyright is thin because it's a grouping of unprotectable elements, so it has to be virtually identical. And so the case that I'd commend you to there is Satava versus Lowry. which held that a selection of clear glass, oblong shroud, bright colors, proportion, vertical orientation, the stereotypical jellyfish form, all considered together lacked sufficient originality. It was not virtually identical between the two pieces of glassware. And contrary to what Francis just said, I think there's no reason whatsoever that a copyright in a musical work should be different from a copyright in anything else, which is what was argued in the en banc. The ruling is going to come out in a few months. I'd like to think that that's where it's going to end up, but there may be other issues in that case that prevent the court from even going there because of the way that appeal is set out. Now, the one that's in front of the court right now is the Katy Perry case. And what happened in the Katy Perry case is the jury found infringement and $3 million worth of damage. And basically all we were talking about in that case was, that's what's similar. I don't know if you could hear that. Those were the two things that were similar in the Katy Perry case. The plaintiff argued that pitch sequence plus the fact that the rhythm of the notes was the same, and that was the rhythm of the notes. Bop, 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 bop. I mean, we probably all can, there's so many songs that have that rhythm that I can't even begin to tell that, to state them. The timbre was the same. Now, the timbre is a sound. The timbre should not even be part of the music copyright because that's part of the production, but yet that was included. The phrase length of the eighth notes, which again is another way of stating the rhythm, and the placement of the ostinato in the sound recordings mix, the ostinato being that repeated figure. And so what happened there is that the defendants have made a motion for, I think it's for a directed verdict, essentially a judgment notwithstanding the verdict. So in other words, the judge is being asked basically take that verdict away from the jury and direct it in favor of the defense. And the main issue there being that it's a thin copyright and is not virtually identical, and therefore that should be reversed. I just want to, I guess I have a minute or two. I just want to respond to a couple of the things that Francis said. The first thing is, it's really not the creators versus the industry in these cases, because as you heard from Sandy, and as I can tell you from my own experience, it's the creators themselves, the songwriters themselves that are freaking out over this. And it's songwriters that are making $0, songwriters that are making $1,000, songwriters that are making $1 million. Because the rule, the fact that these three juries could come out the way they did, which seems so musicologically incorrect, is very scary that these cases can happen. And so what we're at least trying to do in the Katy Perry case is to stop that trend when you have these sort of inconsequential similarities and make sure that there has to be virtual identity. And I think that rule is also at play in the Led Zeppelin en banc. So we stay tuned to see how the law might get refined as the weeks and months go on. I think that's
Great.
pretty good.
All right. Well, Richard, we'll turn it over to you.
So
Thank you again.
as you might imagine, I have quite a bit to say about what's been said by everybody. I'll start, I guess, with this, that in the Blurred Lines case, we had his amicus, Ken's amicus. We had 21 musicologists who filed an amicus saying it was absolutely a copy of Marvin Gaye's Got to Give It Up. So this idea that Ken is proposing that the law should be a certain way, or that music is understood to be a certain way as far as what constitutes copying of a composition, there are, even within the musicology, I'd say, industry, or the musicologists that are at universities across the country and across the world, there's great disagreement. So yes, we had the amicus brief by Ken and his musicologists. We also had 20 of the greatest musicologists in this country, in fact, some of the greatest musicology minds in the world, saying it's absolutely a copy. So the question becomes, what do you do with that? Do we have one person picked by the judge make a decision? No, it's not the way it works. When you have differences of opinion, the Constitution, the Seventh Amendment, says a jury will make the decision. And let me tell you something else. Judges have prejudices. Judges want to get cases off their dockets. One musicologist may have an opinion, but that is not the opinion that counts. The opinion that counts is a jury of your peers deciding what constitutes copyright infringement. And the first speaker said we should be looking at things that are different. Judge Learned Hand said 50 years ago, an infringer cannot avoid liability by showing that which he did not copy. Okay? And this idea that if you take a line, a vocal line, that cannot be enough. I think there was a comment about the Lizzo case, and there was a question about line. That case is actually a little bit different. Because there's other issues involved. There is issues about whether she was a co-writer on the original song. If you're a co-writer, you can't be sued for infringement. There's a question about whether the plaintiffs actually waived their rights in that case. There's all kinds of issues involved. But one line of a composition can be very important. One line of a composition can be very important. I'm going to talk about blurred lines a lot and the disagreements I have with virtually everything Ken just said for the last 15 minutes. But I do want to mention one thing in particular, because Dr. Stewart is here, who actually, and I think he spoke earlier, Dr. Stewart and I worked together in another lifetime back at the Bridgeport days. And I tell this story all the time, and it's one of my favorite stories. And it's relevant because of what Lydia said about a vocal line not being enough. So I filed in the year May 4th, 2001, a day that will live in infamy, I guess, to some, 478 copyright infringement cases against the entire rap music industry. And I call it the Entertainment Lawyers Relief Act of 2001 because every entertainment lawyer in the world had a piece of that case. And I was a kid. It was the beginning of my career pretty much. I didn't know what I was doing, but I filed them. And I remember sitting in a courtroom in Nashville, Tennessee, with virtually every lawyer at every major law firm across the country, in New York, Los Angeles, everywhere, and me, just me, sitting there. And they were all telling the judge how ridiculous these cases were that I just filed. And one of the lawyers from Mitchell, Silverberg, and Knupp stood up and he said, "Let me tell you, Judge, how stupid and idiotic these cases are." He said, "Mr. Busch just sued my client because my client used the word dog in a case, in a song. As if Mr. Busch and his clients own the word dog." Now, this was the use of George Clinton's song Atomic Dog, and there were two pieces that were used. Bow, wow, wow, yippee-yo, yippee-yay, and the word dog. And in Atomic Dog, the word dog ends each sentence. Dog, dog, like that. And in the song that copied it, Dog and Me, it did the same thing. So I remember sitting in a hotel in the Embassy Suites, I think, in Franklin, Tennessee, with Alex years later when we were preparing for the case and working on things. And we said, you know what we should say? And I don't know if it was Alex's idea or mine. Probably I'll give you the credit, Alex. And Alex and I said, one of us said, what we should say is that it's the unique use of the word dog. It is used as musical punctuation in Atomic Dog, and it's used as musical punctuation in Dog and Me as well. And therefore, it is an original use of a non-original word, and therefore, because there's no other song that uses it in that unique way, it's copyright infringement. And we won. And the Sixth Circuit then affirmed that decision, finding that a unique use of a non-original word, even a short word, a word like that, that's not original, can be copyright infringement. And Billboard magazine identified that in New York Times as one of the most important copyright infringement cases of the year, which was 2009. But that's a good example of you can have short small uses. Because remember, the test is whether it's quantifiable, qualitatively or quantitatively important. So it can be quantitatively important or qualitatively important. You can think of small uses of songs that are quite recognizable, that if copied, should be copyright infringement. So there are all kinds of different opinions on what constitutes copyright infringement. I've heard it here today. But what Ken said and what I've heard is not the law. Simply as that. So if you all are familiar with the Ninth Circuit decision in Swirsky and in Three Boys, those are two cases that the Ninth Circuit, it's the Ninth Circuit law. Blurred lines follow those cases to the letter. Judge Cronstadt followed those cases to the letter. And what Swirsky says is there's all types of compositional elements that make up a composition. And there's a list. If you read the case, I'm not going to repeat it here, I don't have the time, but it's all kinds of things that make up a composition. Not just the main melody, not just the things that Ken would suggest make up a song. All kinds of things make up a song. And if the plaintiff can show misappropriation of substantial elements of those types of compositions that are substantially similar, then he's set forth, or she has set forth, a copyright infringement claim. And in Three Boys, and the court also said there's no magic formula. There's no magic formula. And in Three Boys, it was sort of the same analysis as Blurred Lines, but I think much weaker. There were 3 or 4 or 5 elements total, and I believe 3 were not in what was recognized by the lead sheet. I'll talk about the lead sheet very briefly in a moment. But the court found that combination, the unique combination of elements, even if not independently original, can constitute copyright infringement. So that is the law. I agree with Francis absolutely 100% on the thin copyright. Let me tell you what thin copyright is meant to protect. Thin copyright is like you paint a tomato. There's only so many ways to paint a tomato. That's a thin copyright. There are millions of songs, all different. That's not thin copyright because it's creative. There's different ways to do it. And so this idea, and I don't think the Ninth Circuit is ever going to find that this virtual identity thin copyright thing flies. It's a crock of shit. Okay, it really is. Like I said, it's about whether when you paint a basketball or a tomato or something like that. There's only so many ways to do that. So that's what thin copyright is all about. On Blurred Lines, since Ken went after Judith a little bit, I'll note this. It was part of the melody. So there was vocal melodies that were taken. There were 15 different elements that Judith Fennell had identified, not 5 or 4 or 3 like in Three Boys, but 15 different elements that Judith identified that were copied. Vocal elements. There was a combination of the bass line and the keyboard playing together. The notes did match. There was also something that she identified that was really brilliant. And by the way, in Swirsky, the court says that structure, the same structure, is a relevant factor. And in Blurred Lines, there is a rap section that begins, I think, at bar 82 and ends at bar 120. In Got to Give It Up, Marvin Gaye's song, they have a spoken section of that song that begins the exact same bar and ends the exact same bar. In other words, there's no doubt that Blurred Lines, that Got to Give It Up was used as a blueprint for Blurred Lines. Now, it's true that there is more to a copyright infringement case than just music. There's no doubt about that. And there's no doubt that it should be, because things like independent creation and willfulness come about. And importantly, I think I'll mention something to you. I don't know if you have paid attention to this, but this is why juries are the right places for these cases, because they want to do the right thing. They want to find justice. There's no doubt about it. I'm not sure judges do. Certainly a musicologist paid by one side or the other may not want to, but jurors do. So Pharrell Williams in Blurred Lines testified under oath that neither Marvin Gaye's Got to Give It Up nor, neither Marvin Gaye nor Got to Give It Up ever entered his mind while creating Blurred Lines, despite the fact that Robin Thicke said before trial that he told Pharrell to create a song just like that to give it. He said that was not true. Well, Robin Thicke said he was drunk and high, so he didn't know what he was saying. Or he was saying it was meant for promotion, and he was lying. But in any event, Pharrell Williams said neither Marvin Gaye nor Got to Give It Up ever entered in my mind when creating Blurred Lines. The judge relied on that testimony in denying the Gaye family fees. About 3 or 4 months ago, maybe 5 months ago, Pharrell Williams gave an interview in GQ magazine where he was being interviewed by Rick Rubin, and he said that when he creates music, he reverse engineers songs that did something to him emotionally, and that he tries to create that same feeling in another song, and that he did that in Blurred Lines and got himself in trouble. And he said, I made Blurred Lines feel so much like Got to Give It Up that people thought they heard the same thing. Directly contrary to his sworn testimony at trial. We've gone in under Rule 60 now, and we've asked the court to find that Mr. Williams committed perjury, and we've asked the court to reevaluate the issue on fees. And the reason why I mention that is because the result was the right result. The result in Blurred Lines was absolutely the right result. There are 20 musicologists who submitted amicus that say it was, and it fit right within the Ninth Circuit Swirsky decision. I would be remiss if I didn't mention the lead sheet issue very briefly. I've heard that it's been discussed here a little bit, and I just want to touch on it very briefly because it was my case, the Blurred Lines case, where that decision was first announced. And I feel bad about it because the judge in the Torres case, which Francis litigated, followed it, and that's one of the reasons Francis lost that case was because at the district court level was because of the lead sheet issue, and it is a ridiculous decision, just legally and practically. I don't have time to walk through why legally it doesn't make sense. I mean, basically, the 1909 Copyright Act says specifically that copyright protection extends to anything from which music can be reproduced, which certainly is a sound recording. And the Judge Cronstadt's decision was based on a tortured reading of a 1997 amendment to the Copyright Act that doesn't hold water. But from a more fundamental reason, it doesn't make any sense. Marvin Gaye created Got to Give It Up in the studio, right? He didn't sit there and write sheet music. He created the song in the studio while he was playing it. The composition, and by the way, in that same case that I was mentioning with Alex that he and I did, the court even said, the way modern music is created, the composition and the sound recording are essentially the same because the sound recording embodies the composition. You can make some arguments about performance elements, but essentially the composition is what is within the sound recording. That's why the Copyright Office now accepts the deposit copy being a recording of the composition, number one. And number two, there's no doubt in post-1978 cases that the sound recording is relevant to be the best evidence of the composition. So there's several reasons why this ruling is ridiculous. Number one, we would have different rules depending upon whether a pre-January 1, 1978 composition is being infringed. In those cases, you couldn't play the sound recording, but in the post-78 you could, because one's under the 1909 Copyright Act and one's under the 1978 Copyright Act. But even more fundamentally, here's the issue. You're disenfranchising the songwriters who don't know how to write sheet music from what they created. So no longer is Marvin Gaye or any of the great Motown writers the authors of those compositions. It's some after-the-fact transcriber who knows what their education is, who knows what their ability is. They just were, because the Copyright Office did not accept anything other than written notation as a deposit copy prior to 1978, they had to have some sheet music prepared. They prepared a lead sheet that basically was a skeleton just to get the copyright on file. So you're taking all of these works, these pre-78 works, you're disenfranchising these writers from what they created, and you're saying that after the fact transcriber is now the author of some of the greatest songs of all time. You're basically allowing someone now to go to the Copyright Office, check out what's not on the lead sheet, and say, now it's public domain. Now I can copy it for free. And everyone's worried these days about what this means to new artists, but what they're not thinking about is what this means to artists of a different generation who rely on their music to live. And I know I'm out of time, but it's just important to keep in mind that there are policy reasons at play here as well about why this lead sheet issue should not go the way I'm hoping it does not go.
Thank you. That's a really good point to make. Thank you for joining and thanking our panelists. I want to, given our timing, turn it over and make sure we have time to get some questions from the audience before we go and have our reception. As the other panelists have done, we'll start with a question from the students. So if there's anyone in the room who's a student of any type, you don't have to be a law student, please raise your hand so we can start off with you. In the back here.
Okay, I think we can all agree that copyright law doesn't aim to protect ideas, only the expression of ideas. In cases like Gray v. Perry and Skidmore, where there's arguably less original expression at issue than the blurred lines case, if there's no such thing as a thin copyright in music, as some of you were saying, and some of you were saying that you don't believe in dissecting music into its constituent elements, how do you think the court should distinguish between ideas and expression?
That's a good question. That's a very good question. And my answer to that is several things. And that's one thing I wanted to mention, actually. So as was mentioned earlier, it's very difficult, and I agree with Francis on this, it's very difficult to set forth a viable copyright infringement claim. It really is, because the defendants will raise things like prior art. So remember, it has to be original, and there has to be no prior art. It has to be original. So it means what the defendants will do will come in and bring in all the prior art they can to show this is not original expression. So to your point, if it is a basic melody of a few notes, which is what Ken was playing on his piano for us a moment ago, you would think that the defense would be able to come in and say, and I believe Ken said, there's so many songs that are just like that it can't be original. Well, what will happen is they will come in and they will show that to the jury or to the judge, and if they're right, they should get a ruling in their favor. In Blurred Lines, for example, the defendant said that this is just a genre or an era. It's not the copying of the actual composition. But guess what? They couldn't come into court and show actual songs that had the same melody, the same parts that were used. So to Ken's point, if they can do that, that's where, in my mind, that issue arises, where you have to show that it's important, you have to show that it's part of the composition, and you have to show that it's not unoriginal. And if they can show prior art, that will help them defend against the case.
You know, I just want to add one thing to that. In the Katy Perry situation, we actually found, not quite like the database that Francis was talking about, which I also think is kind of suspicious. There is something called Theme Finder, and there's something else called the RISM database. And so, for instance, that was found more than 2,000 times in the RISM database, and many times in the other database as well. There are databases of prior art, and some of the musicologists themselves have access to prior art databases. If it's there, it's there. I agree with that the Blurred Lines case is a little bit different because there's more going on there, and there wasn't going to be something necessarily that was going to be just like that.
And I'll just take a minute to remind Lydia and Francis, you guys can jump in. We can hear you if you want to contribute anything on a question.
My thoughts is this. First off, Richard, I was hoping to meet you in person. We talk on the phone sometimes, so nice to be in this conference with you. I heard Alexander Stewart's there also a brilliant musicologist. So hello to all. For the kids out there, it's really, really neat because you have the two best trial lawyers in the country who are in this conference with you. So good for you. You should ask lots of questions. There's a wealth of knowledge that you'll never get, and it's a very unique thing. You really don't understand that until you actually, well, maybe you guys will graduate, maybe you won't. Maybe you'll pass the bar, maybe you won't. Most likely,
You will.
Most likely, no, honestly, most likely none of you'll see the inside of a courtroom. You'll be stuck in a cubicle doing workman's comp or some sort of defense work. But if you are lucky enough, maybe you can champion these types of cases. Here's what's great about a jury trial. You have the great equalizer. The great equalizer is the jury. The jury is there to make sure there's a fundamental fairness. And look at Richard's case. You can say, oh, this was more feel or groove. The jury got, no matter what, if you think there's less expression in the blurred lines case, it doesn't matter. The jury got it right. Why? They did a preemptive strike and tried to sue the Gaye estate preemptively, and it backfired on them. It's exactly what was supposed to happen. So putting that aside, look, there's no formula. It's not a mathematical formula to figure out what copyright infringement is, right? And it makes it so hard to get in front of the jury to prove your case. But let me talk about a little, like Ken really bothers me. Okay, I'm gonna tell you why. He talks about, oh, it's these songwriters. Now I'm gonna call them out. It's these songwriters that actually are really concerned about this, and they file these amicus briefs in Led Zeppelin. You know what? I analyzed this. I couldn't believe it. 123 songwriters. Do you know what their average wealth was? $4 million. These were CEOs and the top people at the industry. This was not the songwriter who doesn't have anything. These are people that had millions of dollars. Their average net worth of these individuals was higher than anything you could ever imagine, more than anyone in this room. All right. And so when you're talking about, oh, these songwriters that supported Led Zeppelin, it's industry shills. It's disgusting people who do not represent the creatives, but represent those who have a lot. The songwriters, the 1/100th of 1% of songwriters who actually make money writing songs, who are the industry. So let's not be confused with that issue. Second issue, there's no floodgates opening up. There's not a lot of lawsuits that are happening, right? It's very, very few and far between. When you look at slip and falls, there's thousands, hundreds of thousands. When you look at medical malpractice, there's hundreds of thousands. The industry pretends like there's some concern, but all there is a few cases that ever get to the jury.
Great.
And
Thank you.
the real sum effect of that is very, very small. And the jury generally gets it right. Even in our case, the jury got it right. They had a bad comparison. If they listened to the audio, we would have won. But the jury got it right because they were given a bad thing to compare.
Thank you. Thank you very much. We have another question here on this side. There's a mic coming for you. Thank you.
Hi, I'm Professor Plum. I know everyone will now remember that. I teach music business at CU Denver. We talk about this case a lot, and this is primarily for Richard.
Which one?
What's that?
Which case?
The blurred lines case. And what I've explained to my students is that the jury was not allowed to listen and distinguish between the two recordings. And I think that sometimes is confusing for students to understand that. I was just curious if you could expand on that for the students in the room to understand why the jury wasn't allowed to listen between the recordings.
Sure. So that allows me to say that I'm the only one who's ever won a music copyright infringement case without playing music at the trial. So, but it's a joke. But it is true that we cannot play Marvin Gaye's song at trial. So the reason why was because of the lead sheet issue. So what the judge said was that so Judith had identified 15 different elements of Got to Give It Up that were copied in blurred lines. The judge before the trial said that only 4 or 5 were actually reflected in the lead sheet based upon Judith's admission that was the case, and what Sandy Wilbur, who's here also, who was the expert for Pharrell and Robin Thicke, said was reflected by the lead sheet, or at least arguably in the lead sheet. Maybe Sandy disagreed with Judith on that, I don't remember. But the point was that the judge said that as a result of that, we could not play Marvin Gaye's song because to do so would be to expose the jury to elements that he was finding were not relevant because they were not reflected in the lead sheet. So it would be prejudicial to the defendants or the plaintiffs, because they did file the case, that is true, to allow Marvin Gaye's song to be played. But in a weird way, I have to admit that I believe in my mind, in a weird, perverted way, helped us. And the reason why is because if you listen to the totality of Marvin's song and the blurred lines song, There are parts that sound, people will say, the same. There will parts that are admittedly that don't sound the same. And so if we played both songs, you could be distracted by what's not the same. What we were able to do, what the judge allowed us to do, was to make little clips of the parts that we said were similar and that he found were reflected by the lead sheet, and play those clips right next to each other, focusing the jury on the parts that were arguably very similar, if not nearly identical, and that sounded as such. And that, in a weird way, at the end of the day, although when he made that ruling, when he made the lead sheet ruling, I'll tell you, this is important. So I think you'll like this story. So the judge made the lead sheet ruling literally on the eve of trial, and said we could not play Marvin's song like 2 weeks before trial. So I had to call Jan Gaye, that night, and I said, Jan, let me tell you what just happened. And Nona was on the phone, and Jan was on the phone, and I said, the judge, and after that ruling came out, I got a phone call from my opponent, Howard King. And Howard said, Richard, you know you can't win this case. He said, you can't play Marvin's song. You can't compare the two songs. You're going to lose. And let me tell you what's going to happen. The Gaye family doesn't have much money. They rely on their royalties to live. And what's going to happen is, I know this judge, we're going to get our attorney's fees imposed against you because we're going to win. We have over $2 million in attorney's fees, and we're going to get that award, and we're going to garnish all the Gays' money from all their royalties for the foreseeable future, because they don't make that much per year. It's going to be for years. They're going to be homeless, they're going to be destitute, and it's going to be all your fault because you didn't settle the case. So I called Jan and Nona, and I said, this is the decision we got today. We can't play Marvin's song at trial. And this is what Howard tells me is going to happen. This is what his threat to us if we don't settle right now. And Jan paused for a second. She said, let me talk to Nona, and we'll call you back. So I hung up the phone. 30 seconds later, the phone rings. Jan's back on the phone. And she says, Richard, Nona and I talked about it. We have faith in you. You can win this case. We're not giving up. I thought, fuck. So
You said you got to give it up.
So I went to my room, turned off at the hotel, the Doubletree, downtown Doubletree, turned off all the lights, got in the fetal position, was sucking my thumb for a while. Then when I was able to come out of it, I thought, I got to win this case. I can't lose this case. And I think Howard's problem was he thought it was over, and what he didn't realize it just begun. And so I decided what we needed to do was make it so that no jury, no matter what, would rule against us. And we used, as Ken says, we used everything we had at our disposal, all of Robin's statements, all of Pharrell's statements, and Judith prepared these clips that were unbelievable, and that made our case for us, and we won.
Thank you. Well, I see that it's 5 o'clock. We have drinks and snacks waiting for us in the room next door. I hope you will all join us to continue this conversation. Thank you again so much for being here, and thank you for all of the panelists. Thank you very much. Thank you, Lydia and Francis. We wish we could raise a toast to you. You'll have to go have your own drink without us.